Members of the jury, this is an action in which the plaintiff seeks to recover damages for the death of her brother on the ground that she represents those next of kin who were dependent upon him in his lifetime. Some years ago, the legislature of this state provided for the bringing of this kind of an action. Such a right of action did not exist prior to the passing of that law, but under the law as it was adopted and which now exists, an action may be brought by the next of kin to recover against a defendant through whose negligence the death of the relative was caused. But the law limits this kind of recovery. In other words, the law permits no recovery for grief or sympathy or any emotional reason. The law points with a cold-blooded finger at the individual and says that if this man or corporation is liable, he is liable only to the extent of the money value that the decedent was to his relatives, as the case may be. The evidence in this case shows that he did contribute in his lifetime to his sister, who was a witness on the stand, and that he paid her $15 and sometimes $20 a week, and also helped her with her rent. She testified that she was a married woman, but that her husband was a very sick man at the time, and that the brother helped her with her rent and other support. The plaintiff brings this action on two theories, one negligence, the other what we call nuisance. In discussing the first, negligence, in a death case such as this, all that the plaintiff is obligated to show by a fair preponderance of evidence is facts, which would go to establish the condition that the man's death was brought about solely through the negligence of the defendant. Negligence may be a careless act. Likewise, negligence may be a careless omission to do something that a person would be bound to do if he acts as an ordinarily careful and prudent man. As to any contributory negligence on the part of this defendant, there is no obligation on the part of the plaintiff to establish that that duty is on the defendant if he can show it. The other theory on which this action is brought is nuisance, and nuisance is defined in this way. Let us take this kind of an example, a minuscule example. Suppose in the courthouse, in the main floor, there were in the floor leading to the main entrance a vault covered with a door. Obviously, by reason of the nature of the building and the number of people that walk in and out of this building daily, the public authorities would be charged with diligence to see that that cover of that vault was not only substantial but safe. And if it got into a rickety condition and shook in any way or gave any evidence of insecurity, the city would be charged with knowledge of that if it got direct notice. And if it did not get direct notice, it might be charged with knowledge and notice in the form we call constructive notice. And that is that after a condition such as that exists for a certain length of time, which would be sufficient for the public authorities to have discovered that, if their agents were reasonably diligent and observant, and they do not then correct it, then the law would charge the public authorities with negligence in maintaining that, or maintaining a nuisance, and for their failure to correct it after a reasonable time had expired. If anything happens to that and a person is injured, they could be charged in law with having maintained a nuisance because that was a part of the surface on which people walked and which they had a right to anticipate was safe and sound and properly maintained and inspected. In this case, the evidence shows that this man was seen on the 8th floor of this warehouse, that he was putting packages of some kind on a hand truck which had 4 wheels thereon, and he was about 25 feet from this elevator which was at the 8th floor. Very shortly thereafter, the witness Lee heard a fall, and on looking down the shaft of the elevator, saw this man's body at the bottom. Thereafter, he went upstairs and found a truck similar to the one the deceased was using, half on and half off of the elevator car. Boxes of this cereal strewn on the floor, a chain in the rear, not across the opening, and the car is described as having an 18-inch space between the wall and the rear of the elevator.